Hi, I'm attorney Ed Batista, and today's topic is hearsay. Hearsay is any time you're using an out-of-court statement, something somebody said or wrote. You're trying to use that statement to prove the truth of the matter contained in that very statement. So, if John said he buried $1 million underneath his house, and I'm using it to prove that he did in fact bury $1 million under his house, I have a hearsay issue. If, however, I'm using that statement to show that John was crazy, for example, because there's no way he had that money buried there, then I'm not using that statement to prove the truth of the matter contained in the statement. I'm using it for some other thing, and I don't have a hearsay problem, and it stands a better chance of getting into evidence. Another example, same basic facts, would be if it's a theft case and some third person comes to the house and potentially has stolen some money. And I offer John's statement that he buried $1 million. But I'm using it to perhaps show that he was sufficiently on guard, suspicious, or leery of this third person that he even felt that he had to bury $1 million. That would be let in because I'm not using it for the truth of the matter asserted, again, that there's $1 million buried there, but I'm using it to show his state of mind, how he felt about things, and like that. So, once you have a hearsay problem, hearsay issue, because you are using the evidence precisely for the truth of the matter contained in that statement, then you don't get to use it unless you have an exception carved out in law based on certain circumstances. So the big picture there is that other people's out-of-court statements are inherently unreliable for use. That's the baseline idea. It's just a little too unreliable. But there are certain circumstances that are sufficiently reliable, and law has deemed them so that when those circumstances exist, you get to use that hearsay evidence anyway. And remember also that an out-of-court statement need not be verbal. It can be a piece of paper. So if I'm using a piece of paper that says John buried $1 million written by John, that is an out-of-court statement written, but it's still an out-of-court statement and the same rules apply. That's hearsay evidence in a nutshell. Thank you.